Okay, so yes, thank you. Thank you, Senia.
Okay, so why don't we start? If you have an introduction that you'd like to make, I
Yeah.
suggest we start now.
Yes, exactly. I am starting here. Okay, hello everybody. Today, Wednesday, December 7, 2022, 13 Kislev, 5,783. I'm happy to welcome all of you to learn and enjoy our today's presentation. Clarifying Bill 96 by our great speaker, Maître Alain Murad. The topic was suggested by our president, Charles Shemy, and our dear speaker happily volunteered to speak to us on Zoom for the second time with many thanks. Before we start, I would like to express our condolences from the Women Learning Group to our dear friend, Amy Hadid, and her sister, Dr. Samia Bichor, for the loss of their dear brother, Sabah Meir Zubeida Zachrono Livracha, in London. I wish the esteemed family will be consoled by his precious memories. Today is the last of 6 sessions that terminate the fall season of 2022, and it is the 27th series that started in 2009 by Rabbi Shahar Ornstein, following a year of adult bat mitzvah celebrated in July 5, 2009. I hope you enjoyed the whole session.
Okay. All right. Okay.
Okay. My turn.
No, I didn't invite you.
Slicha.
We started with Rabbi Shahar Ornstein, then we had Maurice Perez for dance, we had Audrey Berner, artist, we had Professor David Ben Susan, we had Reverend Daniel Ben Lolo, and today we have Maître Alain Murad. I hope you enjoyed the variety of studies, music and dance from comfortable home. I am inviting now Lisette Shashua to read for us a brief biography of our wonderful speaker, Alain Murad. Lisette Shashua, bevakasha bechavod.
Toda. Thank you, Gladys. And thank you, Alan, for coming and helping us with that terrible bill. Anyway, Alain Murad is Vice President, Legal and Secretary of Canadian clothing retailer Reitmans Canada Limited, where he oversees all of the company's legal requirements. Prior to his time at Reitmans, Alain was a partner in the Montreal office of Davies Ward Phillips and Weinberg, LLP, practicing in the corporate, commercial, intellectual property, information technology, advertising and marketing, and privacy law fields. Alain also practiced in the Montreal office of Borden Ladner Gervais LLP and with the Boston-based law firm Testa Hurwitz and Thibault LLP. Alain is a graduate. Can I ask, what is LLP law?
It's a limited liability partnership.
Oh, limited liability partnership. Thank you. Alain is a graduate of McGill University's Faculties of Law and Management and Concordia University's Faculty of Commerce. Alain also served as a law clerk to the Quebec Court of Appeal and is a member of the bars of Quebec and Massachusetts. Thank you, Alain, for joining us. It's an honor to present you.
Okay, well, thank you very much for your...
Thank you, Lisette. Thank you very much.
Thank
And
you.
now I am inviting Maître Alain Murad.
Okay,
Alain Murad, bevakasha, bechabod.
okay, thank you. My goodness, that's quite an introduction. Okay, thank you, ladies, for having me, and it's a pleasure to be here and a privilege to speak with you today on a topic that is somewhat contentious for non-francophones living in Quebec. It's Bill 96. So what I'm going to do is I'm going to share my screen because I did prepare a PowerPoint presentation, and you can let me know once you see it.
Yes, we see it.
Okay, are you seeing overview of Bill 96?
Exactly, yes.
All right, so let me just move that up here. Okay, so Bill 96. So why is everyone's feathers so ruffled about this new overhaul to the language law in Quebec? I wish I could tell you that there was much ado about nothing, but this law is somewhat, in violation of your rights as Anglophones as Quebec. It's not exactly, in my view, a particularly constitutional law or a law that seeks to unite people. It balkanizes much of the population, in my view, into English and French-speaking peoples. And you'll see that the direction of the law is really no longer a question about promoting the use of French so much as sort of extricating the use of English in Quebec. And it represents sort of a paradigm shift, a philosophical paradigm shift and a legal shift in terms of the way the Quebec government is dealing with assimilation in Quebec and in the way they're choosing to promote the use of the French language. So if you have any questions, just feel free to chime in. There's something like 12 slides or something we can go through. Some of it is a little bit technical. There's a lot to say about this. I tried to distill what I felt was the most important issues. And if you have any questions, just chime in. It is a little bit technical. There's no escaping that when you're dealing with legislation. But feel free to chime in and I could try to answer your questions. So the topic is an overview of Bill 96, an act respecting French, the official and common language of Quebec. All right, so what does Bill 96 do? Well, first of all, it was introduced on the 13th of May, 2021. This was under Legault's premiership. And it was passed in principle 4th of November. So not much longer after it was actually introduced. You could see there was some deliberation that went into this law, but it was passed relatively quickly afterwards. And then by the following year, it was passed fully and it was given royal assent this past June. And it is a major reform to the Charter of the French language. So you all know Bill 101. I guess most of you were around when that was passed, and sort of the great hubbub that took place at the time Bill 101 was passed, because people viewed it as sort of a curtailment of Anglophone rights in Quebec, and sort of the government imposing the mandatory use of the French language. So this is what Bill 96 is really an evolution of that thought, of that piece of legislation, and its enactment really sort of is very telling, because it shows that the Quebec government's efforts, at least in their minds, to keep Quebecers from assimilating into the rest of English-speaking North America and the world at large, wasn't successful under Bill 101, at least not to the extent they wanted it to be. So there's this concern amongst the Quebec legislature that Bill 101 really wasn't achieving what it was intended to achieve. What didn't go far enough. So Bill 96 takes it further. And it's intended to strengthen and affirm the status of French in all spheres of Quebec society. It is a very, very pervasive and invasive piece of legislation. Ostensibly, it tightens the rules governing the use of French language within organizations operating in Quebec. But is its stated purpose really the intention? And as we'll go through this, and I hinted at it earlier, it's really not so much about the promotion of the French language. That was Bill 101. Now they've taken it a step further. Now it's really about preventing the use of the English language, which is a very big paradigm shift, a legal shift, and a philosophical shift. So there's a number of points. There's a lot of things that are touched by this legislation, but there are 5 main points, and we'll go through them now. And I tried to do a little sort of a before and after picture of what Bill 96 did to Bill 101, how it changed it. So French is now Quebec's only official language, especially in the workplace. The main impetus of this legislation is to control the French environments of companies operating within Quebec. It is to make companies operating within Quebec more French, pervasively French, ubiquitously French, to inculcate within the culture of the organization French as the only and supreme language of business, okay? And it does this in a very, very invasive way. And I could tell you that I have a lot of practical experience with it because, you know, I work for Reitmans, and Reitmans historically has been, you know, a sort of a very multi-ethnic type of.
Rachel's on the phone.
Has many, is a sort of a multi-ethnic company. And it has, you know, francophones and anglophones and allophones and all sorts of people. And so we sort of have quite an intimate connection with the Office Québécois de la langue française, the OQLF, which is really the government body in charge of policing this law and enforcing it. So there's a lot of practical experience that I have in this area, and I'll share some of those experiences with you to the extent that I can. So prior to Bill 96, an employer may require knowledge of a language other than French in a job offer when such knowledge is necessary for the performance of the job. Okay, so let's unpack that. Under Bill 101, when you were operating under the auspices of the old legislation, as an employer in Quebec, you can, when you're making a job posting and you're looking to hire someone to fill a particular position, you can require knowledge of a language other than French. You can say, this position requires knowledge of the English language. And typically it's because, you know, Quebec is not 100% homogenously French. There are many different ethnicities, and a lot of people speak English. They don't speak French as well. And let's say you're a company and you're interacting with English people. You'd want knowledge of English as a characteristic of a person that you hire. So what's changed? Now, before requiring knowledge of a language other than French, an employer must meet the following 3 conditions, okay? So the employer has to conduct an assessment to determine the actual language needs associated with the tasks to be performed. They have to sort of do an internal audit, right? Employers, companies operating within Quebec, requiring knowledge of a language other than French to fill a particular position, have to justify that to the government. They have to conduct an internal audit and assess what their actual language needs are that are associated with the tasks to be performed. Then they have to ensure that those needs, that the identified needs in the assessment could not be met by existing staff members who are required to speak the other language. So it's not enough to say, well, to come to a sort of an objective assessment of what your language needs are. You also have to ask yourself, well, the people do I have in place, the people that I have in place, is that sufficient to meet the purposes of you know, dealing with these non-Francophone people, these non-Francophone clients? Do I have enough people already? If I have enough people already, I'm not allowed to hire another person and require that they have a knowledge of language other than French. And then to add, sort of further obligation, there's an obligation to limit, to the extent possible, the number of positions requiring knowledge of a language other than French. Now, that's enormously invasive, right? So if you're a company looking to hire someone and you want to hire someone with knowledge of a language other than French, you actually have to conduct an audit of what your actual language needs are, ensure that the people you have in place are not fulfilling those needs, and then you have an affirmative obligation to actually limit the number of positions requiring knowledge of a language other than French. Now, I can tell you from personal experience, this requires a lot of work. To conduct an audit of this nature requires, dozens and dozens and dozens of person hours. I don't want to offend anyone's sensibilities. And it requires a lot of work, and it's disruptive to the business, because why should I have to justify to the government, to the provincial government, whether or not the number of people I have in place are already sufficient to meet my needs? Or why should I have to limit the number of positions that require a knowledge of it other than French? It's my business. I want to conduct my affairs, and here's the government telling me, no, you can't require English as a language. You're not allowed to. This is a huge sort of paradigm shift for corporations operating in Quebec. It is very burdensome on employers, and it requires employers to carry out a contextual analysis that takes into account all of the positions related to the position to be filled, to ensure that mastery of a language other than French is absolutely necessary. So if you look at an example, you have a company that's looking for English-speaking applicants to serve an international clientele, right? I mean, Quebec isn't the only province in the world, right? Sometimes you're a company that's dealing with international clients, and those clients don't speak French. So this company has to go through this three-step process. It has to demonstrate to the provincial government that, first of all, a significant portion of the services is offered to English-speaking clients, that currently the employees in place required to know English are not able to adequately serve the English-speaking clientele, and that the number of positions for which English is required really is the minimum number needed to serve this clientele. So that's a very, very burdensome exercise, and a very expensive exercise for corporations to undertake, and to have to justify to the French provincial government. It's enormously difficult. It's enormously time consuming. It's very expensive. It's very disruptive to the business, and quite frankly, in my view, quite totalitarian. So what are some of these additional considerations for employers? Well, there are other requirements that Bill 96 imposes on employers. Documentation, right? So I don't know if any of you have ever had to translate documents from English to French. I can assure you it's a long, expensive process because you have to properly capture the idiom of the language and the expressions, especially legal documents, right? I mean, companies like Reitmans pay legal translators huge sums of money to ensure that, for example, contractual documents are properly translated into French, and that the legal terminology is properly translated into French. You can't just plug it into Google Translate. It's a long and expensive process. So companies now, even companies with majority of English-speaking people, have to ensure that their documentation is now translated into French. Employment contracts, application forms, documents dealing with working conditions, training materials, offers of transfer, promotion, termination of employment, all must be written and made accessible in French. And that's a huge requirement and a very expensive requirement for companies to meet. So I'll just pause for a second. Do you have any questions on what I just spoke about? Because it's a lot. Okay.
Alan, I have a question, if I may. It's Albert
Hi,
speaking.
Al.
Let's say in your company, you have a vice president of marketing who's dealing with American suppliers. He's purchasing stuff from the States. Of course, he has to deal with them in English. Now, I'm sure in your company, Reitman's, you have a lot of salespeople in the stores on the floor speaking French. Speaking English. Does that mean you have to take into account these people who speak French to deal with the American suppliers in lieu of the vice president of marketing?
Well, I mean, first of all, those are two. I mean, the salespeople on the
I'm giving extremes here. I'm sorry if I just have to.
the salespeople on the floor dealing with clients are, look, there are certain stores that we have located, for example, stores in the West Island, right, where we have Anglophone or Allophone salespeople, because a lot of the people in the West Island want to be served in French. Now, that's not illegal. We just have to now justify it, right? We have to explain to the government why that's required. As far as dealing with U.S. vendors and U.S. suppliers by the vice presidents within the organization, no, I mean, obviously they don't interact with them in French. They don't speak French. Our vice presidents do. But again, it's a question of having to go through a process of justification to the government why you have to speak to these people in French, in English, excuse me. Why do you have to hire people, in senior positions who are non-Francophone? Why is that necessary? Right. So we have a number of senior executives who may not be Francophone, right? Who may come from the States, who may deal with our international vendors. And, these are sources of contentious debate with representatives of the OQLF, because you have to explain to them why these people have a long and storied history of being experts in their fields, and why it's essential for the company to hire these people in particular, and why they serve a particular purpose that's non-Francophone, and why it's absolutely necessary to have them as opposed to hiring a Francophone within Quebec who doesn't speak English. It's a question of justification. There's a constant interaction, a constant back and forth between us and the OQLF on various issues. There's a lot of policing, there's a lot of oversight. We'll see as we go through the presentation, the additional requirements for companies like ours with over 100 employees to form a comité de francisation and francisization committee that basically has to look at these issues with a microscope and ensure in our dealings with the OQLF how we're going to justify this to them. So it's not a question of basically outlawing the English language. It's making it constructively more difficult to hire people who don't speak French, and so that it encourages people in that sense to hire people that do speak French. But sometimes you can't get around it, right? I mean, you still have to live in the world, and not everyone speaks French, and the OQLF understands that. The provincial government understands that, but it's a question of mitigating the use of any language other than French in the workplace. All right, so the second issue that Bill 96 touches upon is outdoor signage and trademarks, right? So, you're all familiar when you're driving down the Carry, or you see all these billboards and signs, and you all know what trademarks are, right? When you look at your Apple iPhone or you're on your computer and you see Intel or Dell or Microsoft, these are all trademarks, right? So the general rule under Bill 96 is that if public signage is visible from outside French must be clearly predominant, and I mean clearly predominant. It's no longer sort of assessed. You know, we used to joke about the language police coming with rulers and measuring the size of lettering. French, the rule is pretty much French only outside. If it's visible sort of from the broader societal landscape, it's got to be in French. So this is sort of, you know, our reality now, because the Quebec government had done an assessment some years back, and they basically said, well, the commercial landscape of Quebec is simply too English. When you're driving your car and you go to Agrignon and you see Best Buy and you know, Walmart and I don't know what, it looks too English. Everything looks too English. Sort of a broader commentary on the business landscape. So French only outside essentially is pretty much now the rule. Trademarks have also undergone a certain evolution. So previously, if your trademark was registered only in English, if you registered a trademark, do you guys know what trademarks are? Right? You're familiar with what a trademark is, right? It's a symbol or words that function as an indicator of source for certain goods and services. Pretty much everything you see in front of you is a trademark, right? So I'm drinking a cup of tea here. It says Twinings tea. Are you guys familiar with Twinings tea? It's a great British tea, and that's a trademark. If I look at, you know, my iPhone, you know, Netflix, you can see the Netflix logo there. That's a trademark. You know, anything is a trademark. Anything that functions as a source indicator of certain goods and services is a trademark. It used to be when you had a trademark that was registered only in English with no French version filed in the Federal Register, it could be displayed in English only. Then that changed, and there was this requirement to have French, sort of a French generic indicator, right? So it used to be you could have Starbucks, right? You guys know Starbucks, everyone likes Starbucks coffee. And you'd have Starbucks on an outdoor sign, and it's a registered trademark, and there's no French version of Starbucks. It's just Starbucks, right? It's a made up word. And then they said, that's not enough. You can't display Starbucks, even if it's registered in English, even if it's a trademark. You have to have some generic French descriptor. So it would have to be Café Starbucks, right? Les Cafés Starbucks or something like that. You know, Les Vêtements Penningtons or whatever it is. That's not actually an example, but you know, you'd have to have a generic sort of indicator in French that accompanies the English trademark, so that, again, from a sort of a broad societal landscape perspective, French is visible. They want French to be constantly visible because they feel as though that, you know, English only trademarks in the Quebec skyline is going to make Quebec too English. Now, after Bill 96, French really has to appear. And again, I'm not sure how this is going to play out when these issues are actually adjudicated by the Quebec Superior Court and by the OQLF. But French now has to be, you know, really clearly predominant. It has to have a very, very major visual impact, right? So it may no longer be enough to put Les Cafés Starbucks in small print. Maybe you have to change the signage now and make the cafe as big as the Starbucks, right? It's not, these things are hard sort of to police in principle because it's difficult to sort of say, well, the lettering has to be a certain size, but it becomes very much a matter of subjective assessment. And whenever you don't have objective criteria by which to measure right and wrong, when it's dependent upon the subjective opinions of the people policing these issues, you're going to have a lot of inconsistency. You're going to have a lot of very sort of totalitarian behavior because there's no check and balance on what's right, what's really permitted, and what's not permitted. So the space devoted to the French text must be at least twice as large. Characters used in the French must be at least twice as large. Other display features must not reduce the visual impact of the French text. I don't know what that means, right? I mean, really, realistically speaking, you know, what happens if the Starbucks logo, you know, doesn't mesh well with the French cafe and it's, you know, it's eating up a lot of the visual space. Could be problematic, right? So again, it's another example of how invasive and sort of arbitrary and subjective a lot of this is. It's not good for businesses that are trying to govern themselves and to you know, sort of walk the legislative landscape and just conduct their business, and there's this enormous encumbrance, right? So you can also imagine how this disincentivizes a lot of companies, for example, in the United States from doing business in Quebec. I mean, you know, it's not such a huge market. Why go through all of this? You know, why go through, you know, these enormous legislative hoops just to sell, you know, a few articles here and there to Quebec residents? It's not worth it. All right. Third point, advertising, websites, and social media. Are you all with me now? Because I know it's technical and it's complex. And
Yeah, you are doing a great job.
okay, so you're all following. If you have any questions, just feel free to introduce.
Thank you. You are very clear. Thank you.
All right. So advertising, websites, and social media. Everything's got to be now in French, right? So it was the case. I mean, it's always been the case under the French charter that if I have a website, right? So I'm a purveyor of goods and services in Quebec. I have a website. The website has to be equivalent to the English website, right? So if you have a small, you know, home business and you're selling goods and services and you're just trying to eke out, you know, a few extra dollars to pay for your groceries, your website has to be in French. And every time you change it in English, you got to make sure that the French version is at least equivalent, okay? So there's a provision in the French charter and the regulations dealing with catalogs and brochures and pamphlets. All of that applies equally to electronic websites and advertising, okay? Advertising on electronic websites. So they must be accessible to the public. They have to be written in French. It's still possible to use another language, just that's Orwellian, right? You're still allowed to have an English website, provided that the French version is accessible on terms at least as favorable. And provided that the presentation of the French version is displayed at least as prominently as the version in another language. By the way, whenever you hear in another language, it's English, okay? I mean, ostensibly it can apply to any language, but it's English, okay? That's what they're concerned about. They're not concerned about, you know, Russian or Arabic or anything. They're concerned about English. So your website has to be equivalent in every respect. It's actionable if it's not, right? So you can't have the English version containing more information than the French version. You can't have the English version of the website having pictures, you know, posting products, looking more aesthetic than the French version. The French version has to be at least as equivalent, okay? And it applies to publicly available commercial content. So social media, that's huge. That's a huge, huge, huge requirement, right? When keep in mind, like when I'm talking about social media, I'm not just talking about a company's own website. I'm talking about, you know, commentary that the company may post on Facebook, on Instagram, on TikTok, on YouTube, on I don't know what. All of that has to be in French. If it's in English, it's also got to be in French. Now, if you're a company like ours that does a lot of advertising on social media, on online advertising, this is enormously burdensome. Like, you can appreciate, you know, how something like this is very, very difficult for companies like ours, right? Because it's you gotta make sure that every single thing that you post on every single form of social media has a French equivalent, at least as good, at least as predominant, at least as informative, at least as aesthetic, right? This is a lot of work, a lot of work. So it's something that's again enormously burdensome and that's actively policed. So in our dealings with the OQLF, you know, we have to justify essentially the social media posts that we put out there, right? And it doesn't matter if 99% of the people we're reaching are English, because we operate out of Quebec and we're reaching French people. We have to have the equivalent in French. So there's an interesting issue that came up with respect to the extraterritorial application of the French charter to companies located outside of Quebec, if their websites target the Quebec market. And it really hinges on whether or not they have an actual physical establishment in Quebec. Because if they have an establishment in Quebec, they're subject to everything. If a company is just operating out of the United States and they're serving Quebec people, but they don't have a presence in Quebec, well, there's not much the OQLF can do, but they favor sort of an incentive approach to companies like that. They sort of try to work with them to make sure that they provide some French content to Quebecers. And it's sort of a gray area, because it's there, you know, there's a limit to their reach. But if those companies have a presence in Quebec, an establishment in Quebec, assets in Quebec, they're subject to the full requirements of the charter. Contracts. How are you doing so far, folks? Am I boring the life out of you? Welcome to my world. This is what I have to deal with on a daily basis. So,
Alan,
No, Alan, you're scaring the life out of us.
we're scaring the life out of you?
Yeah.
Fine. Well, it gets worse.
Alan, I have
Yeah.
a question here. If you're operating in Quebec, or if you're targeting Quebecers in terms of advertising, why not simply do all the advertising in Quebec in French? Forget about the English.
Well, so that's a reasonable question, and I've had that question come up from many people, disgruntled people. Why is your signage only in French? Well, because it's expensive to make it bilingual. No one's going to fault you no one's going to legally fault you if you make your advertisements only in French. But someone could potentially legally fault you if you make the advertisements in both and the French isn't the equivalent, or the English appears bigger or better, right? So companies are often incentivized to advertise only in French in Quebec because it's a pain in the butt to have to do it in both. But the
Right.
flip side of that is that you're not reaching your customers well, because customers want to be, so there are a lot of Anglophones, especially in Montreal, right? Who are not strong in French, who you can only reach in English. So you'd be sabotaging your own business if you didn't offer them an English alternative. But it's a fine line you have to walk, and it's an extra expense to reach them.
I see.
Contracts.
I have a question.
Yeah.
What's going to happen to the immigrants? Quebec needs immigrants, and most immigrants speak English rather than French. Are they going to be accepted? Are they going to be sent to schools to learn French? Or are they not going to be accepted?
Well, I mean, you're asking a sort of a broader sort of philosophical question. I mean, whether or not they're going to be accepted or not. I mean, I've been living here for 50 years. I've never felt fully accepted. immigrants, Quebec historically has prioritized immigrants from French-speaking countries, right? There's a reason why Quebec has the largest Lebanese diaspora, why they have the largest Tunisian, Moroccan, Algerian diaspora, because those were former French colonies and the people are French-speaking. So Quebec has historically targeted and allowed people from those countries to immigrate to Quebec. To obviate the need to have to be overly concerned about, teaching them French. That being said, there's a lot of immigrants from non-French speaking countries as well. So Quebec has imposed measures which require mandatory education of their children to work and study in French, right? They don't have a choice to send their kids to English schools. They have to send them to French schools. They've closed down so many English schools. There's few left, I can assure you. My wife is a school teacher. So it's sort of like a process of attrition, right? They make it constructively difficult, if not impossible, to function within Quebec without a knowledge of French, and also to be educated in a language other than French. There's a lot of barriers. They impose French language requirements as a condition to to allowing people to immigrate. So yeah, and I mean as to whether or not they'll ever be accepted, your guess is as good as mine. I mean, it depends on the government, right? I mean, if you have a government that's really pure laine in their views, they need the immigrants. You're right. The province is probably in a demographic death spiral because people don't have kids. A lot of the ethnic French Quebecers don't have kids. So they need immigrants to bolster their welfare state and to maintain their confiscatory level of taxation. So they need immigrants. As to whether or not they'll ever fully accept them, ideologically, philosophically, that's another issue that I can't answer.
Thank you.
Contracts. So there are certain type of contracts that must be available in French now. Now, there are two in particular. The first are called contracts of adhesion. This is very legal, technical mumbo jumbo. The other one is a consumer contract. I basically gave you two simple definitions. A contract of adhesion is a contract in which the essential terms and conditions are imposed or drawn up by one party and are not subject to negotiation. So, very often you go in, let's say you're signing a loan agreement with a bank and the bank says, here's the contract. You have to sign it. You can't negotiate that contract. You can't negotiate more favorable terms. It's a contract that's drawn up by one party, the bank, and imposed on the other party, and its terms are not subject to negotiation. That's an example of a contract of adhesion, okay? A consumer contract is a contract between an individual and a professional merchant in its capacity of conducting its business. So for example, what would be an example? You go and you buy an appliance from, I don't know, Best Buy. That's a consumer contract, right? Because you're an individual, you want to buy something, and here's a professional merchant who's selling you this thing. Now, historically, under the Quebec Civil Code, contracts of adhesion and consumer contracts, because there's an imbalance in the power of the respective contractants, because power lies within in the case of a contract of adhesion, the party imposing the contract, and in the case of a consumer contract, the professional merchant who knows a lot more about the product and the service than the individual buying it. Because there's this imbalance in power, these types of contracts are treated differently under the Civil Code. Okay, so the individual tends to have more rights under the Civil Code. So what does Bill 96 do with these two types of contracts? They say you must you must have a French version of the contract that's shown to the person, that's given to the person. Even if the person wants to contract in English, even if the person wants an English version of the contract of adhesion or the consumer contract, he must be given the French version as well. And it's not enough to stipulate that the parties agree that the contract be drafted in English only. No. The person has to be given access to the French version of the contract under pain of nullity of the contract. So do you understand what I just said? These two types of contracts where historically the seller has had more power than the buyer, either because they're a professional merchant or because they're imposing the terms and conditions and they're saying they're not subject to negotiation. In these two types of contracts, it's no longer sufficient for the parties to stipulate that they want to sign an English version of the contract. A French version must be given to them and made accessible to them. Otherwise, the contract is subject to being nullified. Now, you know, for lawyers like myself that often deal in contracts, this is pretty huge, right? Because what is it doing? It's essentially usurping the party's individual will to be served in a language other than French, and being told that you must essentially at least have a French version of this contract. Otherwise, it's all subject to being nullified. That's a pretty big invasion of two parties' ability to negotiate and to deal with, you know, contractually stipulate their terms and conditions with each other. This is a big burden, right? So I'll give you an example, and this is sort of the most kind of legal mumbo jumbo-ish portion of this presentation, because it deals with contractual agreements. Before Bill 96, it was possible to draft a contract exclusively in a language other than French if the parties expressly agreed to this, right? So there are certain boilerplate terms and conditions that we have in our contracts, right? This consent resulted in the insertion of a clause indicating what the parties' wishes were. So, example, the parties hereto confirm that this agreement and all documents relating thereto may be drafted in the English language only. Les parties au présent confirment qu'ils ont accepté que la présente entente et tous les documents s'y rattachant soient rédigés en anglais seulement. In a contract of adhesion and a consumer contract, this provision no longer applies. It is essentially no longer valid. It's no longer sufficient in and of itself to indicate what the parties' wishes are. The parties must receive a French version before entering in the contract. Otherwise, the consent or acceptance of the contract is invalid. Now, again, that is a pretty huge invasion of people's ability to contract. So this is just sort of, yeah, go ahead.
Do these, if you give an Anglophone an English contract and he or she sign the contract, and then you're obligated to give them a French contract, are they obligated to sign that French contract?
No, that's not what I'm saying. I'm not saying they're obligated to sign the French version of the contract. I'm saying that in the case of contracts of adhesion and consumer contracts, a French version of the contract must be made available, accessible, and given to the contracting party. Otherwise, they can use that as a means to nullify the contract.
Yeah, given to the party, but does that mean that the party has to sign, or just to inform them of what the content?
No, they have to be made aware of the French terms and conditions. They don't have to sign the French version of the contract, but they have to be given the terms and conditions of the contract in French. Again, this is sort of to sort of obviate an occurrence where you have a francophone individual who's given a contract, who's signing a consumer contract of a contract of adhesion and doesn't really understand the terms and conditions because they're given to them in English. So you have to give a French version of the contract, regardless of whether or not the parties contractually agree that the contract may be in English only.
Right. But they're not obligated to sign the French version. It's just for information.
They're not obligated to sign the French, at least that's not the way I read it, but. Okay.
Thank you.
So a contract of adhesion or consumer contract entered in a language other than French with no French version having been made available may be annulled at the request of the adhering party with no requirement to prove injury. Okay. We'll skip over the rest, sorry. So yeah, there's also issues with external clauses, but we can skip that because I think that this is too heavy. All right. The language of civil, are you still all with me?
Yes, yes.
You're
thank
all okay? You're not wanting to shoot yourselves? You asked for this. It's complex, the legislation, and that's sort of the nature of the types of presentations that you asked me to give.
We are just happy that we don't have a company of our own.
That's sad, right? It's sad that the Quebec government disincentivizes people from wanting companies of their own because they put in place such onerous legislation.
It sounds much worse than I expected it.
I'm
Alan,
sorry?
I'd like to go back. I'd like to go back to my previous question, Alan, if I may. I'm puzzled by the fact that if you sign an English contract and you're given just a copy of the French version as a form and not signed, then it may not be valid if it's not signed because the guy.
You're misunderstanding, Albert. They don't have, you keep going back to the signing of a French version of the contract. I didn't say that. I'm not saying they must sign a French version of the contract.
But that's the point
I'm
I'm
saying,
making.
no, that's not correct. That's an incorrect interpretation.
I'm saying that, sorry, go ahead. I listened to you first. Go ahead.
I'm telling you that when, in the case of those two types of contracts, a French version must be made available to the person signing the contract. And that merely stipulating within the English version of the contract that it's the party's will and intention to sign an English version is not sufficient to relieve the party, the party imposing the contract of providing a French version. They must provide a French version so that at least the terms or conditions are accessible in French.
Yeah,
They don't have to sign the French version of the contract. They must make the terms and conditions available to that person.
But that is exactly my question, Alan. If they don't sign the French version, then the contract is not valid according to that legislation.
No, that's incorrect. The French version doesn't have to be signed. A person can be made aware of the terms and conditions in French to inform themselves of what the French terms and conditions mean, but still sign the English version. It's not, you keep getting hung up on this requirement of having to sign the French version. All the requirement is that the French version has to be made available. So they may sign the French version if they want. They don't have to, but an English version is not valid unless the French version is made available to them. Because someone may be not 100% comfortable in English, may want to reference the French version to make sure that their knowledge and consent is really crystallized.
I understand that.
Yeah.
I understand. But you were saying before also that clause that says the parties have agreed that this contract be signed in English.
Yeah,
And
I'm saying that's no longer
that is no longer valid. So if that's no longer valid, then the English contract they signed is no longer valid.
I'm saying if you go back to what I said, the consent was on the insertion clause. Okay, inserting such a clause is no longer sufficient. The parties must receive the French version before entering into the contract. So by itself, this is no longer sufficient. But with this, and and providing the French version of the contract, hypothetically, you should be okay. In many cases, it may result in people signing the French version of the contract, but in other cases, it may not.
Without knowing what they're signing, if they don't understand French.
Well, they still have the English version. You're presenting both versions.
Mhm.
All right, language of civil administration. The language of civil administration is essentially, your dealings with the government. Okay, so whenever you have to deal with a government body, with a government office, right? It's departments, it's agencies. There's a mandatory requirement to do so essentially in French. Okay. All applications submitted to any part of any civil administration, applications for grants, financial assistance, to become part of a Quebec program, whatever assistance, whatever Quebec government agency or department you are submitting a communication to, must be in French. Okay, there are certain exceptions, and those exceptions have to deal with when there's essentially money involved, right? Because they don't want to muck about with people's finances, right? So they recognize that loan agreements, financial instruments, contracts entered into by the Quebec government, whose object is the management of financial risks, et cetera. Those are sort of, there's carve outs to those exceptions. So those contracts can be made available in English. But essentially, when you're dealing with the Quebec government, you have to deal with any Quebec government agency or department, you must do so in French, except with those sort of limited exceptions. And this is, I mean, you could have a presentation for like 3 hours just on this. It's quite huge, and there's a lot of provisions dealing with this. But the idea is that when you're dealing with a Quebec government agency, it has to be in French, except for those sort of exceptions dealing with, loan agreements and agreements dealing with the management of financial risks. All right. We're nearing the end, so you can all breathe a sigh of relief. Franchisation of companies in relations with the OQLF. Companies with fewer than 25 employees don't have to typically deal with the OQLF. But if someone complains, they'll have to deal with the OQLF. Companies from 25 employees or more, it used to be 50, now it's down to 25, must deal with the OQLF, okay? And companies with 100 employees or more, not only do they have to deal with the OQLF, but they have to create a comité de francisation, a Francisization committee, to ensure that French is made pervasive within the body of the corporation. And there's a lot of obligations here, and it's a lot of work and a lot of time spent and a lot of back and forth and a lot of having to justify why this software is not in French and this software is only in English, and why the out of office message is of this individual is in English and not in French, and why the telephone message doesn't have French first instead of English. It's a whole balagan, okay? It really, really is. But that's what this committee, and I sit on the Francisation, I chair it at Reitman's, and I can tell you it eats up a lot of time. It's quite frustrating, and very often, you get lucky, and the people that you're dealing with at the OQLF are reasonable. Sometimes they're more reasonable than other times. Sorry, I'm just going back. I notice, yes, Quebec court cases. Okay, hold on. I'm just going through your comments now. Sorry, I wasn't getting these before. Why is Canada as a whole and Quebec in particular automatically bilingual, and therefore all Canadians are equally speakers of French and English? Therefore, Anglophone institutions and people can easily communicate in both according to local law. I'm not really quite sure what your question is. Why is Canada and Quebec automatically bilingual? Canada has 2 official languages. So as a matter of federal legislation, French and English are the official languages of Canada. In Quebec, French is the only official language. So there's always this tension between Quebec and the Quebec provincial government and the Canadian federal governments, right? And they don't often do things the same way. They certainly don't see things the same way. This is terribly disturbing. Do English speakers have no rights in this, a first world country? It's not really a question that I can answer. Yes, you have rights, but your language rights have been curtailed. Arabic restaurants and supermarkets have their signs saying workers needed in Arabic only. No one notices. I don't think the French government is concerned about Arabic as in English. English is really, that's what I was saying before, English is really the issue. But technically the French charter would apply to the Arabic language as well. Quebec court cases, yeah, there's a lot of provisions in Bill 96 dealing with Quebec court cases. I'm not going to get into that, but they have to be, the submissions have to be in French. That's sort of the nature of the way we work here. On this case, should the English version requested by the client state, client has viewed the French version? I think I answered that. And then you might want to explain, according to the code of ethics, a lawyer must ensure that his or her client understands the terms of the contract. Thank you, Jimmy. That's another issue relating to the question that you had posed earlier, Albert, about, a contract. I could go on for hours about nullity of contracts and there not being a crystallization of consent and understanding. I'm not going to do that, but yes, a lawyer has an obligation, but this is really in the context of two contracting parties. They're not necessarily lawyers, but yes, a lawyer has an obligation to ensure that his client understands the contract. All right, so just getting back to the slide, you got to register with the OQLF. You got to provide them with information on legal and functional structure of the company. You have to have a designated representative. You have to have an analysis of the company's linguistic situation, the implementation of a franchisation program to make sure that French is used within the company at all levels. Guys, there's a big bureaucracy involved here, and there really is a lot of sort of government oversight over the minutia of what a company does. It's disruptive. It's invasive. What can I tell you? This is the situation for Quebec companies, and there's no way around it. It's the law of the land. And then even once you get your franchisation certificate, like we have a certificat de francisation from the OQLF. We got it back in the 90s, but there's a constant oversight. It's not like once you get the certificate, you're home free. That's not the way it works. There's a constant oversight. And you have to justify it every 3 years, and you have to have an entente particulière, which is another sort of provision in the act dealing with specific agreements that the OQLF reaches with companies to allow them to function in an environment that's not 100% francophone, just because of the company's particular needs. Last slide, second to last slide. There are sanctions. These are the sanctions dealing with non-compliance. Businesses which the OQLF has refused to issue a franchisation certificate or which is suspended or canceled an attestation are included on a list published on the OQLF website. So there's a blacklist of companies that aren't sufficiently French in Quebec. In addition to the reputational impact that they may suffer, enterprises on this list may also be subject to, they won't be able to contract with Quebec government bodies, and they may also be subject to fines. There's one thing I would bring your attention to is this idea called the private right of action. Now, private rights of action are just a nightmare for lawyers like me that work in industry, but for lawyers who work in law firms, it's like manna from heaven. So you see these private rights of action in privacy legislation, in anti-spam legislation, now in the French language charter. And what these private rights of action essentially allow people to do is to form classes and to file class action suits directly against companies, either because their privacy rights were breached or because the company was in violation of anti-spam legislation, or in this case, because they're in violation of the French charter requirements. And what this does, it is incentivizes people to file lawsuits against companies, to form individual classes and to file lawsuits against companies because they think they can make money. And there's a lot of law firms that work on a contingency fee basis, which means basically that if they win, they get a cut of the action, right? And companies are incentivized to settle. This type of thing goes on a lot in the United States, where the settlements are huge in class actions. And law firms can make millions of dollars simply by settling with companies, because companies are incentivized to settle. They don't want the expense of litigation. They just want to make it go away. So there are these private rights of actions that are now available under Bill 96. You can read the complaint. It's a complaints-based system, by the way. The way the French charter works is that they typically wait until someone complains, right? So, very often I'll be minding my own business, doing my work at my desk, and then I get a letter or an email saying that some customer complained that, your TikTok advertisement wasn't in French. So this causes a mad scramble, and I have to speak with the marketing people, and I have to go back to the OQLF and tell them the situation has been remedied. That TikTok advertisement is now in French. That's the system. They give you formal notice to comply, and if you fail, it could order compliance. And if you contravene an order, you may be subject to penal and civil sanctions, injunctive measures that are enforceable by the Superior Court of Quebec. First offense, second offense, subsequent offenses. Each day constitutes a separate offense, depending on what you did. And they have a lot of discretion and power. What does Bill 96 really represent? Whereas Bill 101 was concerned more with the promotion of the use of the French language in the workplace and broader society, now there has been an ideological shift to extricating the English language from the workplace and broader society. This is a very different approach and represents an attempt to stamp out Anglophone cultural and linguistic influence in Quebec. And on that basis, ladies and gentlemen, I will turn the floor over to you. That is a brief overview of Bill 96.
I have another question. Do you think a lot of English-speaking Jews will leave Quebec after that bill?
You're asking me questions that I don't have an answer to. It's like you're asking sort of these broad, sort of open-ended philosophical questions. I have no idea. I mean, there was a huge exodus of companies and businesses during the time of the first referendum. Toronto was built largely on the backs of Quebec when businesses just upped and they left. They took their head offices and moved them to Ontario, where they didn't have to deal with this nightmarish thing. A lot of people moved to Toronto. I moved to the States. I would never have come back had I not been forced essentially to come back. So you're asking me, some people are comfortable here. Some people are ensconced, living their lives well. It's still a peaceable province. You don't have bombs going over your head. You don't have mass shootings. You're living your life peaceably and well. As I often say, this level of peace and prosperity is not the default position of the human condition. So people are still living well here. Will there be an exodus? I don't think so. Will some people be incentivized to leave? I certainly think so. Would I encourage my own children to leave when they graduate? Probably. I'd want them to try out what their life in the States. Your guess is as good as mine how this affects people. but
Thank
if
you.
you'll forgive the expression, it's a shit show.
Alan,
Thank you.
Alan, is there a notwithstanding clause within that piece of legislation? And the second part of my question, is the federal government doing anything about this?
Well, first of all, notwithstanding clause is in the federal constitution, and it allows Quebec to essentially derogate constitutional rights from people. So no, there's no notwithstanding clause in the French charter, because the people who are running it are the ones who essentially have the exclusive right to invoke the notwithstanding clause to violate your rights. So they don't need a notwithstanding clause. What was your second question, Albert?
If the federal government has any say in the matter?
Well, they don't have any say in it because the federal government essentially operates as a quasi-independent nation within the Canadian federal constitutional family. They've always maintained their status as a distinct society, and they have a notwithstanding clause for that reason. They can do whatever the bloody hell they want. And if it's in a violation of the federal constitution, too bad. So, you know, what can the federal government do? Well, other than, you know, sound and fury, not much. The Quebec government does what it does, and too bad.
Is there anything that the English community can do to fight this?
Well, look, I mean, people have been very vocal in raising concerns, but it's the law of the land now. It's an enacted piece of legislation. It makes things more difficult for companies operating within Quebec that are not, you know, if you're SNC-Lavalin or, you know, a Pelado company or Pomerleau or whatever, you don't give a crap. You're already French. It doesn't matter. But if you're a company like ours, or if you're an American-based company doing business in Quebec with establishments in Quebec, those are the people feeling it. It's not Bombardier, and you know, they're already French. They're the darlings of the Quebec government. It's a question of, you know, sort of managing your ability to conduct business in a lawful way, and at the same time not overburdening yourself to the point that it disrupts your business. It disrupts your ability to conduct your business. And it's a fine line. It's hard to do that because there's a lot of time involved in this type of thing.
Would someone like Best Buy have to change their name, their trademark, or is that?
They don't have to change their trademark. They have to be concerned about the outdoor signage, right? To make sure that there's a genetic modifier there that is very, very visible in French, that balances out the English in their registered trademark.
You
So,
wouldn't have to
yeah,
call it
there's expenses.
Meilleur achat.
You know, it's expensive to, you know, I don't know, those outdoor signs are a fortune.
Absolutely.
Yeah. So you have to, like, all of a sudden now add things to them and change the visual landscape. And it's not a simple thing.
Hello, Mr. Archibald. Good to see you.
How are you?
I'm good, Baruch Hashem.
Yeah, I'm welcoming you from another time zone. Maître Murad, do you mind if I add a couple of comments?
Please do.
I certainly don't want to disrupt the operation here.
No operation to disrupt.
I'm speaking to you from a jurisdiction that has 24 official languages. So the problem is a little bit more complicated here sometimes. But just to go back to your presentation, which was extremely well put together, thank you very much. Great job. But there are a couple of points that people might want to think about in the future. I'm not going to make a critical comment, but there are issues that people, I think, should bear in mind. There's a huge debate right now in countries that have linguistic legislation, and there are many, between two terms that are used. And Alain mentioned one of them at the beginning. One term is assimilation, and the other term is integration. And so there's a huge debate right now as to what that actually means on the ground when you're looking at companies, for instance, where the country wants them to integrate into the economic system of the country. And the economic system could be a socio-economic system. So there's a huge debate, especially within the European community, as to how that actually works. The other part of it is the social engineering part of it, where you're looking at policies which are assimilationist policies. And the perfect example of that is France, where in terms of immigration, their policy is an assimilationist policy. I don't think that Quebec policy is an assimilationist policy because they recognize the cultural communities, they recognize that there is difference, etc., but they want them to march to a certain drumbeat. Anyway, so those are two terms that are important to keep in mind, etc. The other issue is the official languages. So in fact, yes, Canada has two official languages, and Quebec has, after this piece of legislation and others, has one official language. But there also is a distinction between official languages and national languages. And in Bill 101 and in the Charter as revised, there's also a recognition of Aboriginal languages, and there's a recognition of Inuit. And so one could even argue that if you speak Inuit, maybe you have more rights than an Anglophone living in Montreal. But if you read the actual documents, you see that there's a special attention paid to Aboriginal languages and to Inuit. The other issue which you addressed, thank you very much, is the issue of the right to understand. In European legislation, the right to understand is considered to be a fundamental right. And so any citizen who does not understand something in terms of legal obligations or requirements, etc., can exercise the right in front of the courts in order to ensure that their rights to understand have been respected by the court system. That would be interesting to see how that could play itself out in the Canadian courts. The final comment that I wanted to make was that the issue of ongoing proof of competency or ongoing proof of compliance is a major question. So companies, once they obtain their certificat de francisation, for instance, they may not be out of the woods yet because it may come back to visit them again, depending on what happens. And furthermore, any professional, for instance, who comes into Quebec from outside, has to prove his or her competence in the French language, which is considered to be a professional competence, will be subject to professional inspection. And if during the professional inspection, they determine that the particular professional has not maintained his or her competency in French in order to meet the requirements of the profession and to protect the public, there can be sanctions in those particular cases. So it's a very pervasive piece of legislation when you look at things like that. It can affect everybody's life and your people's ability to earn their daily bread. So it's something which I think requires a lot of public education so that people can actually understand what all this means and how it affects their everyday life as citizens and as people who participate in an economy. So a great presentation because it gave a great overview of the whole thing, but we're not out of the woods yet. And there are a lot of issues that are going to be discussed. And our friends at the Supreme Court of Canada are going to have probably a bit of work to do in order to try to untangle some of the contentious issues that are going to come up. And if my friend Julius Gray has his way, he's going to keep himself busy for a while to come. Thanks a lot.
Yeah, Jim and Alain, even the cost of translating huge legal documents, deeds and things like that, it's onerous.
Yeah, I mean, if you were to choose a profession and you're really comfortable in both English and French, I would tell you become a legal translator. You'll make a lot of
Yeah.
money.
I published an article earlier this year, and one of the comments in the article was that the order of translators in Quebec must be jumping up and down with glee.
For sure. Yeah.
You took the words out of my mouth, Jim.
Yeah.
I think if you wanted to go into a career now, go into translation
Yeah,
and work in a legal office, in a lawyer's office. These guys are going to make a pile of money with all these contracts and dealing with all the different issues that arise from that. Having said all that, Alan, I want to say that this was an amazing, excellent presentation. I learned a lot from you, and I want to thank you so much for this very
You're
well
most
put together
welcome.
presentation.
Thank you. You're most welcome.
Excellent. I
have
wasn't
to
familiar with all the I wasn't familiar with all the details and the intricacies of that piece of legislation. Now I do, and it's just
We have to thank Charles for suggesting this topic. Charles Shimmy, our president.
Yeah, is he on? Is he on? No, he's not. Okay. Oh, he can. I guess you're recording it, so you can watch it on YouTube if you want to put yourself to sleep.
yeah, Alain, you're going to be a star. You're going to be on YouTube now.
No, yay! You know how much I love that.
So Alain, you're gonna have to nitpick and go into every little thing now. It makes your job much more hair raising.
Yeah, look, I mean, I'll be honest with you. I mean, it's a lot of work. I mean, dealing with the OQLF is not always easy, but very often, you know, they understand. I mean, they're trying. They have a job to do also, and there are a lot of them that are very sympathetic. I mean, there are a lot of people that I work with there that are our current guy is fantastic. He's a lovely, lovely guy, very understanding, very reasonable, very accommodating, trying to, you know, to work with us. Every so often you deal with people that are sort of less accommodating. They're more sort of, you know, pure laine, that are very, you know, more serious and unbending. But that's not often the case. It's usually there's an understanding that what they're doing is disruptive, is invasive to businesses, and they want to work with you. They need to justify their own sinecures working for the Quebec government. So it's not always, you know, but it's a lot of extra work and a lot of extra expense, and you know that diverts resources and time away from other things that you could be working on and spending money on. But that's you know, the price you pay for living in Quebec. I mean, there's a lot of positives, a lot of benefits to living. It's a beautiful province. Montreal's a wonderful city. You know, it's very cosmopolitan. It's very gentrified. They're great restaurants, and, like, you know, there's a lot of positives about living here. It's not just the OQLF and the French language chart. It just makes it more cumbersome for businesses. And that's sort of, you know, that's the price you pay, I guess.
So, like, let's say in our synagogue, the registers of births and marriages, they have to be translated too.
Well, when you're dealing with the civil administration, yeah, you have to provide French language versions of applications and things like that. I don't know to what extent you're going to be required to retroactively sort of translate things. I mean, I don't look. There's also a practical reality, right? What's on paper, you know, is one thing. So very often, you know, when you're applying the law, there are practical considerations, human considerations come into play, and ultimately, you know, there is a requirement to be reasonable. So it is draconian, but it's not, you know, draconian to the point that you become completely dysfunctional. It's not. It doesn't work like that.
On the one hand, Alan, I like the advantages that you highlighted of living here in Quebec. It's fantastic. We live quite well. We're very happy. On the other hand, it's so restrictive, that piece of legislation, that it's going to prevent outside investments from wherever.
It definitely can. It has the potential to affect, because it's an extra hurdle. It's a huge
economically
hurdle to
and financially speaking, we're limiting ourselves to outside investments.
Yeah, but that's nothing new. That's nothing new. I mean, you know, there's so many businesses conducting business in Ontario that don't come into Quebec. I mean, how long did it take for Banana Republic to come here? There's a lot of companies that historically have shied away from doing business. in
Well,
the
Target is one. Remember Target? They came to Quebec and then they had
Target,
to
yeah.
leave.
Well, that was a whole.
They
other
left
thing.
because of all the hassles they had.
Well, I mean, that's
Harsh.
a bit of an oversimplification. There was a lot of issues with Targets.
You know why they failed here? Because they weren't able to comply with Quebec laws and the Quebec market. They thought they could operate here the same way they operate in the States, but
Yeah,
marketing.
but I think it's an oversimplification to attribute that solely to the French language issue.
No, that's what I'm
there was
saying.
a lot.
That's the point I'm trying to make, is that the marketing aspect here in Quebec is different from the States or elsewhere. And they did not take that into account. And they thought that they could just operate here the same way they operate elsewhere. And that's just not the case. Quebec consumers are not the same as New York consumers.
Okay, mes amis. So on that happy note.
Okay, I would like to thank you very much.
It's a great pleasure, and it's always nice to see all of you. And if you have any questions, you can always reach out to me directly.
Thank
And
you,
I wish
Alain, for a great
all
presentation.
the best, and see you on Shabbat.
Thank you.
Thank you,
I would
Alain.
like to thank Alain so much. You did a great job.
You're
Whatever
welcome.
I Googled, whatever I read, you did the best. You did it
Okay.
exactly to our own understanding, to our capacity to understand. Thank you. That's a
Okay.
great job.
You're most welcome. You're most welcome.
Thank